So let us go back to section 1 of the Land Act. And you remember section 1 identifies 6 interests. We'll list the 6 again and we'll take each of them to explain. 1, the allodial title. 2, the common law freehold. 3, the customary law freehold. 4, the usufructuary interest. 5, the leasehold interest. And 6, the customary tenancy. So we shall begin with the first one, which is the allodial interest or the allodial title. What is the allodial title? Now, the allodial title has been explained in section 2 of Act 1036. And this is how section 2 of Act 1036 defines the allodial title. Section 2 says that allodial title is A, the highest or ultimate interest in land, and it is held by the state or a stool or skin or clan or family or an individual, and may have been acquired through compulsory acquisition, conquest, pioneer, discovery, and settlement, gifts, purchase, or agreements. So that is the definition of allodial title under section 2 of Act 1036. Is the highest or ultimate interest in land. And section 2 does a very good job by telling you where the allodial title may be located. That it may be located in either the state, the stool, or skin, or clan or family, or an individual. So section 2 does not only define the allodial title, it's also very helpful in letting you know the categories of persons that can own and hold the allodial title. The state can hold the allodial title. A stool can hold the allodial title. A skin can hold the allodial title. A clan can hold the allodial title. A family can hold the allodial title. An individual can hold the allodial title. Not only does section 2 tell us the categories of persons that own the allodial title, section 2 also tells us the different modes by which the allodial title can be acquired. It says they may have been acquired through compulsory acquisition, through conquest, pioneer discovery, and settlement, gifts, purchase, or agreement. So section 2 is very important as far as its statement about the allodial title is concerned. It doesn't only tell us the definition of the allodial title as the highest or ultimate interest, it tells us the categories of persons that can hold the allodial title. And it also gives us an indication about the modes through which the allodial title can be acquired. Now, there's a reason why I'm dwelling on this section 2 as far as the allodial title is concerned. This is because prior to the coming into force of this Land Act of 2020 and 1036, there is this notorious case of Ohimin versus Ajay and another, which is reported in 1957 to West African Law Reports at page 275. And in this case, there was an extensive discussion about the principal modes through which the allodial title may be acquired. And I quote from the case as follows. Now, there are 4 principal methods by which a stool acquires land. They are conquest and subsequent settlement thereon, and cultivation by subject of the stool. There's discovery by hunters or pioneers of the stool of unoccupied land and subsequent settlements, and use thereof by the stool and its subjects. That's number 2. Then give to the stool. Then we also have purchase by the stool. That is what was held in Ohimin and Ajay 4 principal methods: conquest, discovery, gift, and purchase. And this case was started in 1957. 4 principal methods. So if today under Section 2 of our Land Act, we have gone above that one, and then we have compulsory acquisition as part of the modes of acquiring the allodial title, I must draw your attention to that. Because if you're going to rely on Ohimi and Eje alone, you realize that it may not be too helpful for you in identifying the modes of acquiring the allodial title. So if you compare what is mentioned in Ohimi and Eje, the 4 principal methods, if you compare that one to what we have under the Land Act, you will realize that the Land Act goes beyond what has been listed in Ohimi and Eje. And I think they go hand in hand, because Ohimi and Eje didn't say that the only methods of acquiring the allodial interest are those 4 ways. Ohimi and Eje said the principal methods, meaning that they agree that there could be other methods of acquiring the allodial interest. So Ohimi and Eje mentioned 4 principal methods. It didn't say 4 only methods. It said 4 principal. And the Land Act 2 has given us other ways too that it may be what? Acquired. So the Land Act pops up in Ohimi and Eje and adds compulsory acquisition and adds agreements. Because Ohimi and Eje, we have only conquest, discovery, gifts, and purchase. But in the Land Act, we have all those 4, and we also have agreements, and we have compulsory acquisition. So in the Land Act, we are given 6 ways in which the allodial title may be acquired. Now, let me briefly comment about these 6 ways that have been listed under Section 2. Now, you realize that today, in this present day and age, nobody can go and say you have conquered somebody to take over their land. Traditional states do not go to war to conquer people. It will be criminal. These days, there are no ownerless lands in Ghana. So since there are no ownerless lands, you can't say you want to discover somebody's land, so you have taken over it. So conquest and discovery by hunters today may not be applicable because there are no ownerless lands in Ghana as we speak. And we will not allow you to go and conquer people, the Gans or the Ashantis or the Elders, and say that you've conquered them and taken over their land. So conquest and discovery will be deemed to be old ways of acquiring the allodial title, but they are still important. Because you'll be surprised that there will be cases that are before our present courts. And then the people would have to prove their ownership by showing that their ancestors conquered a particular people before they acquired the land. So even though today you cannot acquire land by conquest, the knowledge that you can acquire the allodial interest by conquest is still very important for the lawyer. Because there are cases before the courts where people are tracing their ownership for 1,000 years ago to say that their ancestors are people who discovered the land. So even though I'm saying that they are no more practical today, conquest and discovery, I'm not saying they are no more relevant, because there are people who will have to rely on that to prove their ownership of their lands. But in present day Ghana, the present ways you can end up acquiring the allodial title will be gifts, purchase, agreement, and then compulsory acquisition. Compulsory acquisition. Those ones, they may still be applicable. Now, let me briefly give you an indication, even though we've already mentioned it, of the people that can hold the allodial title. Remember, Section 2 mentioned that it can be the state by compulsory acquisition. So if you look at Article 20 of our 1992 Constitution, it tells you that the state has the power to compulsorily acquire land and pay the people from whom they compulsorily acquire the land the appropriate compensation. So once the state compulsorily acquires land in the public interest, then the state will be deemed to have acquired the allodial title. They will not own any obligation to anybody again. So it have acquired the allodial title. In some books, you see this one being referred to as the eminence domain of the state. Eminence domain, the right of the state to compulsorily acquire land in the public interest. And then, if you come to the location of the allodial title in the Stool I refer you to look at the case of Jamestown, Allodial Stool, and another, versus Sempe Stool and another, reported in 1989-90, 2 Ghana law reports at page 393. Now, if you read this case and you look at the holding as captured in the head notes, this is what was said in the holding. And I quote, "The history of Jamestown showed clearly that it was constituted by 3 quarters, namely Akumaji, Alata, and Sempe, and that their property was vested in the Jamestown Manche. Each quarter could only claim ownership to an area which was in its exclusive possession. It would therefore be wrong for any one of the 3 stools to claim for itself the allodial title to all Jamestown lands." So, this case gives an indication that the allodial title can be located in the stool. So, authority for proposition that the allodial title can be located in the stool. Remember the case of Jamestown, Allodial Stool, and another, versus Sempe Stool and another. Because it is in this case that the court held that the history of Jamestown showed clearly that it was constituted by 3 quarters, Akumaji, Alata, and Sempe, and their property was vested in the Jamestown Manche. Jamestown Manche is the chief of Jamestown. Jamestown Manche. And what the quarters could only do was only to claim ownership to an area which was in their exclusive possession. But those quarters can never claim to be the allodial titles of those lands that are in their possession, because the person that has the allodial title to those lands is the Jamestown Stool. If you want authority for the proposition that allodial title can be located in the stool, remember Jamestown Allodial Stool versus Sempe Stool, 1989-90, 2 Ghana law reports at page 393. And if you want authority for the position that the allodial title can be located in a family, for that, I refer you to the case of Amioda versus Pordia. Amioda versus Pordia, and Amioda versus Forzi and others consolidated. Reported the 1967 Ghana law reports at page 479. In this case, Apalu JA at page 491 of the report said as follows, and I quote, "The lands in Ningo are not stool lands, but they are owned by families or quarters, and that the lands in dispute belong to the appellant's family." Quote ends. What I want you to note about the dictum of Apalu in Amioda versus Pordia is that the lands in Ningo are not stool lands, but they are owned by families or quarters. It means that it is only the families that own the allodial title at Ningo. So if you go to Ningo and a stool is about to sell land to you, to say they have the allodial title, remember Amioda and Pordia, that Ningo lands are not stool lands and they are only family lands. This is telling you that the lands that the family can own the allodial title. And this position in Amioda and Pordia has been affirmed in the case of Pram Paramount Stool versus Central University and 2 others. Suit number H1/19/2011 unreported. So Ningo lands are not stool lands, they are family lands. And their families own the allodial title to Ningo lands. And if you want an authority for the possession that The allodial title can be vested in families. Remember, Amioda versus Pordia. But what about individuals? Is there any case that has affirmed that the allodial title can be vested in individuals? I refer you to the case of Nyasemhwe and another versus Afidi Esan. Nyasemhwe is spelled Nyasemhwe. Nyasemhwe and another versus Afidi Esan. Afidi Esan is spelled AfibiyEsan. Reported in 1977. One Ghana law report at page 27. Look at the holding one. You realize that the allodial title can be located in an individual. So we have said enough about the allodial title. We know it's a registrable interest in land. We know that it's the highest or ultimate interest in land. We know how it can be acquired, as we've seen from Ohimin and Ejay and section 2 of Act 1036. We've seen the persons in whom the allodial title can be located. So we've said enough about the allodial title. Now let's move on to the next registrable interest in land, which is the customary law freehold. The customary law freehold. This customary law freehold is also referred to in some books as the derivative title. Derivative title because it is derived out of the allodial title. But what is this customary law freehold? How do we define this customary law freehold? We refer to section 3 of Act 1036. And this is what section 3 says about the customary law freehold. The customary law freehold, and I'm quoting from section 3 of Act 1036. Customary law freehold is an interest which arises from a transaction under customary law